All right, I hereby call this meeting to order. Good morning. I will be the Code Enforcement Special Magistrate for today's hearing. I want to begin by explaining how the process is going to work. We generally hear building cases on the agenda first, and the city will call the cases as they appear on the agenda. If you have appeared at today's hearing, your case will be called before those where no one has appeared. But that's only true if you've signed in. So if you haven't signed in, please check with a code officer in the rear of the chamber, and they will make sure that you get signed in. Once your case is called, I ask that you come down to the podium on my right-hand side, which is right over here. The city will put on its testimony and evidence first. You'll have an opportunity to review the evidence and ask questions of any of the city's witnesses. You'll also have the opportunity to testify and present me with your own evidence. Once I have the testimony and evidence, I will make a ruling. I will enter a written order either today at the hearing or in the next few days, which you'll receive a copy of. If you have any questions as we go through the process, please feel free to ask them. This is not meant to be a formal courtroom. The formal rules of evidence do not apply here. However, although this is not a formal courtroom, all testimony is taken under oath under penalty of perjury. So if you think you're going to testify, or there's a possibility that you might testify, I'd ask that you stand and raise your right hand, and I will swear you in. Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury under the laws of the state of Florida? Yes, sir. Please be seated. The city can call their first case.
Case number 17, CEBLD 250-20717, case address 1551 North Flagler Drive.
I'm sorry, which number was this? 17 it is. Go ahead, sir.
Good morning. My name is Peter Valenti. I'm a inspection coordinator for the City of West Palm Beach Building Department. And for this case, at 1551 North Flagler Drive, we had a balcony handrail that the intention was good to replace it, repair it, a section of it. But unfortunately, a permit was never pulled. So the handrail was installed without a permit and was not exactly in a good, secure way. So I could tell you that the violation was issued. The stop work order was posted on February 18th, 2025. It was mailed via certified mail and regular mail on April 29th, 2025. Posted at City Hall May 1st, 2025, and posted on the property on April 30th, 2025. Certified mail was delivered on May 1st, and I've already stated the observations, but basically that's what it comes down to, is needing a permit, installed without a permit. There are some photos, and they are accurate. I've got one photo up there that shows the installation. You can see how it's mechanically fastened, and it's a bit loose. If we could find that. I do. Can you?
So tell me what I'm looking at.
So you're on a balcony. This is off 1551 North Flagler. The direction you're looking is more towards the south on this balcony. And you can see the section of handrail, the way it's installed. Well, again, those photos don't appear to be in the system. I thought they were, because you got the other ones.
Well, either way, it's your testimony that these require this requires a permit, then, and there's no permit on file.
Exactly.
Okay. Counsel?
Good morning, sir. Did you take the photos that you showed to Special Magistrate? Did you take those photos yourself?
Yes.
Okay, and do those photos truthfully and accurately depict the rail that you're alleging needs a work permit for?
Yes.
Okay. Special Magistrate, the city would like to enter the case file, including the photos and testimony into evidence barring any objection.
I'm going to accept the photographs and testimony and evidence. Ma'am, can you tell me your name, please?
Good morning. My name's Annabelle Steens. I'm here on behalf of the Slade Condominium Association.
I'm sorry, can you say your name one more time into the mic?
Annabelle Steens.
Annabelle,
Steens, S-T-E-E-N-S.
and Ms. Steens, what's your position with Slade Condominium?
I'm the general manager.
So the city is telling me that you guys installed a handrail without a permit. So what happened?
Correct. Now, this happened prior to me becoming the general manager at the Slade. Since then, since I got the stop work order from Peter, I have contracted with a metalworks contractor. It was hard to find someone who was willing to take on such a small project to begin with. And we have submitted for permitting now, as of May 2nd.
What's the city remedy the city's asking for?
I'm sorry, could you repeat that?
What's the remedy that you're seeking here?
Well, get right to it. It's 30 days to get the permit approved and the installation. I could tell you that since Annabelle has come on board, she's really taken care of it. We do have a permit application in, but we want to make sure we get it all done, so I don't know if 30 days, but that's what we recommend. 30 days, $100 a day fee.
Is 30 days enough time to get this done?
I believe so at this point,
Sorry.
since they've got the application in.
Go ahead, Ms. Skeens.
The only thing we're waiting on is the permitting. The contractor is ready to go with a 1-week turnaround time. So 30 days should be sufficient.
Anything further, council?
They're from the city.
All right, I'll give you the 30 days in case CEBLD 25020717. I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of FPC 105.1, which is the installation of the handrail without a permit. Respondent has 30 days to bring the property into compliance, or a fine of up to $100 per day may issue. Good luck.
Thank you.
Agenda case number 8. Okay. CEBLD 250-20713, case address 1012 Palm Beach Lakes Boulevard.
Anytime you're ready, sir.
I'm Kevin Pennington, Building Inspector for the City of West Palm Beach. The code case number is CEBLD 250200713. The address where the violation occurred is 1012 Palm Beach Lakes Boulevard. The violation I observed is a new fence, air conditioning equipment, electrical work, doors and window replacement. Issued the violation and stop work order on the property February 12, 2025. The notice of violation was mailed via certified mail and regular mail on April 23rd, 2025. The certified mail, as of May 19th, was still in transit. It was posted at City Hall on May 1st, 2025. It was posted on the property April 24th, 2025. To support my observations of the violation are new chain link fence, new air conditioning equipment, electrical work, doors and window replacement. The photos being shown truthfully and accurately depict the alleged violation and reflect what I'm testifying to. Permits and inspections are required for the work I observed and for what is displayed on the photos shown. Some permits have been applied for, some permits have been issued, and some permits have been performed. Included in my file is a copy of the notice of violation and the affidavit of posting. I've had contact with the mechanical contractor, and they intend to submit permits and complete inspections. City recommends 120 days to comply and $50 fine per day after that. The time to bring the alleged violations into compliance is a reasonable amount of time. I'm submitting the evidence, a copy of this case file, including the documents relied upon.
Thank you, sir. Special Magistrate, the city would like to enter the case file, including the photos and testimony, into evidence, barring any objection.
Sir, can you tell me your name?
Good morning. My name is Joel Barrett. I'm with Joel Barrett, PA. I'm the newly appointed manager for 1012 Palm Beach Lakes Boulevard.
I'm sorry, can you tell me your name one more time, a little slower?
Joel Barrett, Joelbarrett.
And sir, your position?
Yes, I'm the newly appointed manager on behalf of PBL Boulevard, LLC.
Do you have any objections to the documents or testimony?
No, I've spoke with Kevin numerous times, and we did complete the fence permit. We currently have the HVAC as well as the windows and doors in progress right now, so we are getting towards the final here. And
Right.
no objection to the 120 days. We're completely fine with that.
All right, I'm going to accept into evidence the evidentiary case file in this case as city's composite exhibit, including the photos and documents. If the city wants to give you 120 days to bring the property into compliance, sir, is that enough time for you?
More than enough. Fair enough.
All right. All right, in case CEBLD 25020713, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of FBC 110.3 and FBC 105.1, which is inspections and building permits for the fence, electrical, AC, doors, and windows. Respondent has 120 days to bring the property in compliance, or a fine of up to $50 per day may issue. Good luck, sir. Make sure you stay in contact with the code officer, all right?
Thank you, sir.
Case number 12, CEBLD 2503074, case address 419 49th Street.
Good morning. My name is Ryan Brown. I am the Chief Plumbing Inspector for the City of West Palm Beach. The code case number is CEBLD 25030724. The address where the violation occurred is 419 49th Street. The violation I observed is renovations without permits and inspections. I issued a violation and posted a stop work order on the job on 3/5/25. The notice of violation was mailed via certified mail and regular mail on 4/24/25, posted to City Hall on 5/1/25, and posted on the property on 4/23/25. The certified mail was, a notice was left at the address on file, but there was no authorized recipient to sign for it, so it was returned. The observations that I observed while I was there was a paver driveway or patio area that was being installed without permits. I walked with the owner to see the interior renovations of the upstairs apartment, which included flooring, kitchen remodel, and bathroom remodel. I also witnessed some garage renovations while I was there, that some partition walls were being removed between the 3 separate garages that were on the property. Pictures. The pictures I have in my file, which should match the ones shown, do truthfully and accurately depict the alleged violation that I'm testifying to. Permits and inspections are required for the work that I observed and for what is displayed in the pictures. There were a couple of permits that have been applied for prior to the violation, but no activity since then. They are not issued yet. Permits numbers are 2503, 1355 for the garage doors, and permit 2503-0240 for the screen enclosure. Neither one have been issued yet. So no inspections have been performed on any of the work that was done without a permit. Included in my file is a copy of the notice of violation and the affidavit of posting. I have had contact with the owner the day that I wrote the red tag. Beyond that, no attempt at communication has happened. The result of that contact was very non-cooperative,
stating that she didn't believe that the permits were required, which they most certainly are. The city recommends 120 days to get all the permits and at least a passing inspection to bring it into compliance, or $100 a day after that. I believe that time to bring the alleged violation into compliance is more than reasonable. And I am submitting as evidence a copy of the case file, including all the documents relied upon.
Thank you, sir. Nothing further from the city at this time.
Ma'am, can you tell me your name, please?
Sherry Wilkinson.
Can you say it into the microphone?
Sherry Wilkinson.
Ms. Wilkinson, it says the owner here is the Haplo Eshon Trust.
Yeah, I'm a trustee.
Are you a trustee?
Mhm.
You can go ahead and pull the microphone down to your mouth so we can hear you. Okay. Do you have any objections to the documents they want to submit in evidence?
Yes.
All right, tell me what your objection to the documents is.
I told Mr. Brown that he,
Before we get into the case, I just need to know if you object to the documents.
I do.
Okay, so what's your objection to the document?
My objection is you have to have permission from the owner to be able to take pictures, to enter into the property. He waited 2.5 hours. I'm sorry. I didn't even realize that this was on. He waited 2.5 hours. I was not there. I told them not to allow anyone in because we have a permit on file for renovation already. I don't think Mr. Brown saw that, and
Okay, so, hold on, you're not objecting to the documents, you're objecting to what he did, so.
I'm
gonna accept
objecting
it.
to the documents, the pictures, I'm objecting to that. They were taken with, which I believe is trespass. You're not
So
supposed to.
you're
take-
objecting to the pictures because you don't
Yeah.
think he had a right to take them?
Exactly.
Right, how were you in the apartment?
When I arrived, there were some workers. Walked up to the front door. I asked if anybody was there. They said no. They picked up the phone. They called somebody. I assume it was her. I waited for her to show up, and I walked around with her the entire time. I did not go in the property without her presence. Everywhere I went, I asked for permission. I told her that I assumed that the work upstairs was done without a permit based on the description the other people had told me. She claimed it had not, and I told her, I said, well, if you let me walk up there and look at it, I'll give you my opinion on whether it needs a permit or not. And she allowed me to walk in. She even told me to watch my step, everything. So I certainly had permission.
Ma'am, did you walk around with the code officer?
No, he said that if I don't allow him in the property, he was going to put a stop order and make my life miserable, which is what I didn't want. I objected the entire time for him to come there because what he didn't understand is that I know I already did a lien search on the property. It had a lot of problems, and I was going through each and every permit. There's a remodel permit already. He doesn't understand that, and this is the problem. There's a remodel permit that's a valid permit on this property that was there, and the only thing we're doing is maintenance on that property. Because it was boarded up by the city, it ended up with termites. We did have to remove, I don't know, this was not part of the original structure that was being removed in the garages he took a picture of. It's not part of the original structure. It's supposed to be totally open. We're trying to put the property back in the original structure for the permits that were there.
All right, so a couple of things. First, I'm going to accept the pictures and evidence into evidence. But let's get to, so the gravamen of this is that she's claiming that she has a permit and you're claiming that she needs a permit. So can you walk me through what she has and why you think she needs more permits?
She has a permit for a screen enclosure, which would be like a second floor patio. So that, like, you know, when they have a patio rail and they decide to screen
She
that
says
off.
she has a renovation permit.
I don't believe so. Not that I'm aware of, and I've looked at the file.
Ma'am, do you have any document showing this renovation
Yeah,
permit?
okay, so what happened is, we have the valid permits, the expired permits that we are working on. And there's
Can
two,
you show,
three.
can you show the
yeah.
documents to the code officer,
Sure.
to the building official?
I'm going to give, I'm going to give I'm going to pass this to you. I have this, and then I'm going to pass the other set to him.
You can give it to me.
Well, I need you to interpret what she has. I'm not a building official, I don't know.
Okay. So what she showed me is the same thing that she showed me the day I was there. She was holding up her phone and telling me what didn't require a permit. And I even tried to explain it to her at the time that at the bottom of the page where she is referring to what does or doesn't require a permit refers to 1 and 2 family. And the building is not a 1 and 2 family home or structure. It is 3 apartments with 3 garages, which makes it residential multifamily, so it doesn't fall under any of the exemptions that she is pointing out that doesn't require a permit. I tried to make that clear when I was there, but that was part of the continued disagreement that I was trying to mislead her, so.
If you go to page, turn it from there, the building itself, the structure of the building was painted. That does not require a permit, and I
Not part of the
stated.
violation.
That's not, okay. The violation that was posted on the.
All right, hold on, because this is getting very confusing even to me.
Okay.
What do you believe that she needs a permit for as of today?
Pictures of the apartment that I walked through show the flooring, bathroom, and kitchen remodel, which requires permits and inspections.
Okay,
The patio driveway area, whatever she wants to call it, is hardscape and requires at very least a zoning permit. Those are the things that are listed on the red tag and part of the violation, and that's what I'm asking for.
All right, ma'am, can you speak specifically to those permits, why you think you don't need those?
okay. Driveway, I did not touch. So I don't need a permit for a driveway that I haven't even started as yet. I will need a permit once the city issues water. There's no water going through that property at all. Now, his
All right, let's
violation,
stop there. So she says she doesn't need one for the driveway, did you say, I didn't hear you say driveway, I heard you say.
At the time when I observed it, it was questionable whether it was driveway or patio area. When I told her that she needed a permit for the driveway, she said it's not a driveway. I said, but you're putting in pavers as hardscape, which requires a permit. I explained it to her. So since then, I've been there, she's completed the work, and it has been kind of sectioned off from the driveway as a, quote, patio area. Still requires a permit.
All right.
That's why in the violation, it's marked as a paver driveway area.
it's
All right,
not,
so patio is the first one, okay, what's the second thing?
The interior renovation. So the upstairs unit had new flooring put down, bathroom and kitchen remodel, which requires a permit.
All right, ma'am, can you speak to that? Why do you think you don't need a permit for the interior renovation?
okay, because there's an existing permit already that's there. If
Okay,
you look-
what is the existing permit number?
Okay, I'm gonna give it to you. Existing permit 06050091. It's expired, but it only needs a $75 fee and a final inspection.
That would
Hold on one
be,
second, are you familiar with that
Number
permit?
Number
Hold
0604.
on, one at a time. I can only deal with this at one at a time.
I'm-
Are you familiar with that permit? Is she right that that permit covers what she's talking about?
that's from 2006, an expired permit, and the work was current and ongoing. So that permit wouldn't apply to the work that's being performed during the violation.
Okay, what else you got?
But that's not true, because the place was vacant the entire time. The permit is for those particular things. Those things are there. All we did was regrout everything. The permit is there for 06050091 and 06041251. To get another remodeling permit would mean that expired permit will still be existing. I have the right to open that permit, have a final inspection on it, and get it closed. You know how many expired permits are here because the property was vacant?
Okay, well,
There's-
I'm not going to speak to how you remedy, but currently, whether it's expired or whether it can be reinstated, it's not
It's
currently valid.
reinstatable, it's a matter of law, it's reinstatable with $75 fee, it's reinstatable, and that's what I was going.
All
All
right,
I'm
well,
doing is maintenance
Okay,
for the
and
property.
so we have the patio, we have the interior renovation, what else, is there anything else?
Those are the two things that are the major
Oh.
part of the violation.
All right,
Sir? An
So let me-
expired permit from a previous code cycle cannot just be reinstated. It's not that simple.
no,
Especially if the work is
I'm not
current.
gonna instruct her on how to bring it into compliance, but whether Whether you believe you can reinstate it and whether the city believes you can reinstate it, I'm not going to solve that problem for you. But currently, as it stands, there isn't a working valid permit that exists as of today. There's this old one that you think you can reinstate that the city doesn't think you can, but there isn't one now because it hasn't been reinstated, right?
Correct.
So you did the work without reinstating
I
the
didn't
permit.
do any work. I didn't do any work is what I'm trying to say. All we're doing is maintaining the property. We did the painting, we did the basic things. Those work was already done. This is what I'm trying to explain to you. And the violation is for 105.1, which states any owner or authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure. He's talking about interior of the property. That's not the building or the structure. The building or the structure is the outside part, the roof, and so forth and on. We have permits for those that did not encompass the old
Mr. Redd, can you
permits.
speak to why you believe that the interior renovation needs a permit?
1051 says any system, structure, any system including plumbing, electrical, mechanical, all systems that are constructed, modified, installed, require a permit.
But it's not
It's
been
not just the
modified.
outside of the building that's restricted to permitting.
But it's not
Ms.
been
Wilkins, I'll
modified.
give you the last word before I make a ruling.
Okay, you're talking about modification. When you do first of all, the reason there was a remodel is because the electrical was changed in 2006, 2007. So you had it changed from gas to electric. Those things were done already. That permit needs to be closed. It needs to be reopened, and it needs to be closed. The only thing is missing is a final inspection. So you can't call for a final inspection without the water. I asked for the water to be turned on. They haven't turned the water on. Once the water goes on, we tried to get the water on from 2017 to close these permits, which is a remodel. We paid for a new tap to the sewer, a lateral sewer tap, and for a permit for the water, for the meter for the water. We still do not have those things from 2017. All this is doing is causing problems for this building because they're asking to put the cart before the horse. You have to have water there in order for this permit to be closed out because it includes plumbing. And in order to have a plumbing inspection pass and a final, you need water. And all the remodel, whatever was done before, all the stuff was done before, all I'm doing is coming in and making sure everything is in proper order, so when they put the water on finally, which I paid for already and hasn't been done since 2017, right now we have a notice of claim with the commissioner for this exact same thing. There's no water on the building. You cannot have a final inspection. So to order me to do something which I'm trying to fix without their assistance, without the utility assistance, would be
Hold on one sec. Do you understand why there's no water here?
The utility issue and the violation are two totally separate issues, that she can resolve the utility issue and has no effect on what we do, and our stuff has no effect on what they do.
Any reason to believe that this couldn't be accomplished in 120 days?
It cannot be accomplished in 120 days
Why
when you
can't it
try
be
to walk.
accomplished in 120
Because
days?
we've been trying to get water since 2017. If we couldn't get water from 2017 to close out plumbing, how are we going to be able to do a renovation and close that out in 120 days? First, we need to have, this needs to be abated or step up to civil court. The reason I put a notice of claim in with the commissioner is because I'm ready to go to lawsuit. I'm ready to go to civil court because we're entitled to water. If they don't want to issue water, the next step for us after civil court is to drill to get water in. No, there is no way you're going to have a renovation permit which includes plumbing and do not have water. there's an irrigation here also in
Hold on, 'cause you're
2013.
repeating yourself over and over again, and it's not making it any clearer to me. Do you
Okay,
understand
so
what this issue
we
is?
need water.
Yeah, the issue that she has is with utilities. The original property was one parcel, had two apartment buildings. Then it was split and sold. She owns one side on the right, another person, and I've been in communication with the other person on the left. There were three buildings altogether. The front building, which faces the street, now has its own private meter and water source. The building back on the left has its own private meter and water source. She has still not obtained her private meter and water source directly to her building for her property the parcel was split into three pieces. So that is her problem with utilities, and it is something that she's been fighting with utilities. Our case has no effect on the utility issue, and the utility issue has no effect on ours other than the lack of the water. Her lack of, and I will tell you, I've spoken at length with Vicki Galton, the Director of Customer Service at Utilities, and has explained that there has been a lack of cooperation with the owner, and that is why they still sit the way they do today.
Okay, I'm going to have a last word on that. That's not true. There was a previous owner that was there. He was pretty much ridiculous at times, but we paid for the water. We paid for the lateral tap, and we paid for the water. I paid for it personally.
While I'm not unsympathetic to the notion that you need to get water, I don't understand why it's taken 8 years to do so.
Well, you have to ask Vicki Galton, because what happened was, let me explain. You're supposed to, this is code enforcement also, and this is the problem with code enforcement, because what's going to happen is, which is what they did, is going to become a chronic nuisance by what he's trying to do, and this is deliberate. He came out there to inspect to see if I had water or not, and that's what he came to do, because Vicki Galton asked him to go out there. And when he looked, there was no water, but because we were out there painting the exterior of the building, we have permit, we did the roof, we did permit for the, we have a permit pending for different other things in there. They get upset. The building is not supposed to be touched and all this kind of stuff. So we're trying to make sure. I had to pay $15,000 for property tax. I'm not gonna let that property not be maintained. So basically, all I'm doing is maintaining the property. I came in there, I cleaned up all the shrubbery, make sure there's no falling anything on there. When he put a stop
I think
order.
that's all good. I can't solve all your issues.
Okay,
'cause
so
it's-
what we need to do is abate this and go for another time, but
I'm
you
not-
can't, I don't want to.
I'm not going to do that. I think what is relatively clear to me
Mm-hmm.
is the things that you did, whether it's a reinstated permit or not, it needs to be permitted properly. So this is what I'm going to rule in case CEBLD 25030724, that the property is in violation of FPC 1010.3 and FPC 105.1, which is it needs to be properly permitted. I'm not going to tell you how to do that. If you think you can do it through reinstatement, whatever you want to
I'm
try
gonna
to do.
object to what you're saying.
Just, hold
Be-
on. You can object all you want, but this is what I'm ruling. So I'm going to give you 120 days to get the patio or driveway, whatever you want to call it, properly permitted, and I'll give you 120 days to get the interior renovation properly permitted. If you don't do that, it could be subject to a fine of up to $100 per day. Good luck. I don't know how to help you solve your problems, but it has to be permitted one way or another.
But the patio hasn't even been touched yet. We applied for a permit.
Ma'am, I'm done. That's it.
Okay, so I can appeal this, right?
I can't give you legal advice, but there are always options.
Okay, I'll appeal it, because it makes no sense. I'll go to court. Thank you.
Case number 21, CE 250-13293. Case address 5001 Pinewood Avenue. There she is.
Anytime you're ready.
Good morning, City of West Palm Beach Code Enforcement Officer Paul McFarland. On January 30th, the property at 5001 Pinewood Avenue was cited for 74-34-A-1-H trash can placement. 22-32-A certificate of use. 105.1 failure to obtain building permits for the window and door changeout in the shed. 94-482-A, unpaved parking. 22-441, rental license violation. And 18-106-A, clean and sanitary. All violations have since come into compliance. The only violation that is not in compliance is the 105.1. The permits have not been issued for the windows and doors and the shed. The property as well as City Hall was posted on January 31st. Certified mail and regular mail was sent January 30th. Certified mail was signed for May 7th. I have been in touch with a representative of the property. They have been working diligently to get the property into compliance. They have since applied for the permits on March 27th and are working through the permitting process. With that being said, city's recommending 90 days to bring the property into full compliance, or $100 a day until compliance is achieved.
Ma'am, can you tell me your name, please?
Sandra Rizzo.
I'm sorry, one more time?
Sandra Rizzo, R-I-Z-O.
Ms. Arizo, it says the owner is
Myra Pineda.
Ira Panetta. Who's that
Yeah.
to you?
My sister.
Are you living at the property, ma'am?
No, I do not. She's out of the country because her mom passed away.
Did she give you permission to represent her here?
She did.
Does the city have any objection?
No objection from the city.
Yeah, she does. She's been hand in hand with her sister. Even when I met them, she was with her sister, so I'm pretty sure she has permission.
Ma'am, do you have any objection to any of the testimony or evidence that the city has presented?
No.
Without objection, I'll accept and evidence the evidentiary case file in this case, including the testimony and evidence and pictures as city's composite exhibit. The city says that you've done everything except for the building permits and wants to give you 90 days to get that into compliance.
Yeah, not objection. I just want to ask if maybe we can get more time, maybe 120
Why do you need more
days.
time?
Because we need to get a general contractor, and the windows and shed already exist since she bought the house about over 10 years ago, so she never did any changes.
How much time do you think you need?
120 days, if it's possible.
I don't object because looking back on the window and door permits, it has been rejected. So they do have to do some work to resubmit it. So I'm inclined to take the 120 days.
All right. In case CE 250132393, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of FPC 105.1, which is the failure to obtain windows and door permits. Respondent has 120 days to bring the property in compliance, or a fine of up to $100 per day may issue. Good luck, man.
Okay, thank you.
Case number 1, CEBLD 24100-648, case address 2121 North Tamarind Avenue.
Is that it for sign-ins? Is anyone else here?
Doesn't look like it.
Why don't we do this one and then we can figure out what that one is? All right. Okay.
Good morning. Richard Burnell, Chief Building Inspector, City of West Palm. It's in reference to code case CEBLD 2410-0648, 2121 North Tamarind. The violation I observed was the installation of 3 bathrooms without required permits. Issued the violation. A stop work order was posted on October 1st of 2024. Certified mail was mailed out on April 25th, 2025, was posted at City Hall May 1st, 2025, was posted on the property April 25 of 2025. Certified mail was delivered on May 1st, 2025. The observations I made where the violation was the bathrooms were installed without required permits. The pictures that are being shown, those aren't those, right? Oh, there you go. Pictures are truthfully and accurately depict the alleged violation and reflect what I'm testifying to. Permits and inspections are required for the work I observed and what is displayed at the pictures shown. The permit, the demo permit was applied for. They decided to take all the bathrooms out. It hasn't been issued yet. No inspection have been performed. Included in my file is a copy of the notice of violation and affidavit of posting. I have had contact with the property manager a few months ago. That's the last time I heard from her. The results of the contact were they applied for the demo permit, went through plan review, they had comments, they haven't addressed the comments yet. City recommends 60 days to comply and 100 days, $100 a day after that. The time to bring the alleged violations to compliance is a reasonable amount of time. I am submitting the evidence, a copy of the case file, including the documents relied upon.
Thank you, sir. Nothing further from the city for right now.
I'll accept in evidence the evidence case file in this case and the photos and testimony of the officer of city's composite exhibit. So they applied for a demo permit, which was not
Yeah, they're
issued?
applying for a demo permit rather than try to get a permit to have they're all finished. So rather than
So
do
they
that,
actually
they
did the
decided to
bath-
take
they-
it all back out. I said, that's fine, as long as you want to do that, that's up to you.
So,
They're
so
gonna
they,
tear the-
they actually put the new bathrooms in without a permit?
Yeah.
So I
So
guess,
rather than get a plumbing permit and all that other stuff to demo it, they're just going to take them all out.
why would they do that?
I don't know.
Instead
They
of
asked
just
me, is it okay to do it that way? I said, sure, if that's what you want to do, but
So I guess if they demoed it and put it back, then that would be compliance,
that would
right?
comply, right?
Also, compliance would be just getting the permit.
Correct, which they already applied for. They just haven't addressed the comments yet.
Okay, in CEB LD 241000648, I make the following findings of fact and law. I find notice is sufficient. I find the property violation of FBC 105.1, failure to obtain a permit in the renovation of the 3 bathrooms. Responded at 60 days to bring it to compliance, however they want to do it, within 60 days, or a fine of $100 per day may issue.
Thank you.
We have one more person present for case number 19, CE 250-43428. Case address is 513 Green Springs Place.
Good morning, City of West Palm Beach Code Enforcement Officer Paul McFarland. On April 1st, the property at 513 Green Springs Place was cited for 22-441 business tax receipt for rental violation, 18-103-E, repair of windows and doors to make weather tight. The sliding glass door is damaged and in need of repair. 22-32-A, certificate of use. The property as well as City Hall was posted May 13th. Certified mail and the regular mail was sent April 15th. Certified mail was signed for May 7th. I have been in contact with representation of the property. We have since applied for the rental license. We still have an inspection that needs to be completed. Representation is requesting more time to get the unit empty and get possession of the property so the repairs can be completed. With that being said, city's recommending 90 days to bring the property into compliance, or $200 a day until compliance is achieved.
Thank you, sir. And Mr. McFarland, do you believe 90 days is a reasonable amount of time for the property owner to come in compliance?
Yes, because they're going through an eviction process and the hearing date has been set, so that should give enough time to go through that process and get the property back in possession.
Thank you, sir. Special Magistrate, the city would like to enter the case file, including photos and testimony, into evidence, barring any objection.
Sir, can you tell me your name, please?
Hi, good morning. My name is Javier Medina.
I'm sorry, one more time, a little slower.
Sure, Javier Medina.
Mayhem?
Javier Medina.
Sir, do you have any objections to the photographs or documents that the city would like to put in evidence? All right.
No,
objection,
sir.
I'll accept in evidence those photos, documents, and testimony of the code officer. So the city says that you're trying to get a rental license, but you need more time, and they want to give you 90 days.
Yes, sir, that is correct. No objections.
And you know you have to do the repairs as well, right?
Yes, sir, correct.
All right. All right, in case CE 2504342A, to make the following findings of fact and law, I find notice is sufficient. I find the property in violation of the listed code sections. Give the respondent 90 days to bring the property in compliance, or a fine of up to $200 per day may issue. 90 days is a good amount of time, but it comes very, very quickly. Make sure you stay in contact with the code officer and let him know
course, sir.
immediately when you're in compliance, okay?
Yes, sir, of course.
All right, good luck.
Thank you.
Thank you so much.
I believe that's everyone that's present at the moment, so we're going back to the agenda. Case number 3, CE 250-43440, case address 1121 11th Street 2 has been complied. Case number 5, CE,
What happened with 3?
3 has been complied.
Complied, okay.
Yeah. So, case number 5, CEB LD 2411068, case address 4915 Pinewood Avenue.
So a lot of building cases today.
Good morning. My name is Raymond Stevenson. I'm an inspector for the city of West Palm Beach. Code case number CEB LD 2411068. The address where the violation occurred, 4915 Pinewood Avenue. The violation I observed is that they removed and replaced some rafters on a lean-to roof rafters, and they built a utility room without a permit and inspections. I issued a violation and posted the stop work order on the job 11th to 13th 24. The notice of violation was mailed via certified mail and regular mail on the 4th to 25th. Was posted at the City Hall on the 5th to the 1st, 25th. Was posted on the property on the 4th to 25th to the 25th. The certified mail was picked up on the 5th to the 1st, 25th. The observation I made after I did doing a roof inspection, somebody had taken down a lot of rafters on like on a lean-to roof. So it was going to the wall with some columns, wrought iron columns. And they also built a brand new utility room. This was without a permit or inspections. The picture being shown truthfully and accurately depicts alleged violation and reflect what I am testifying to. Permits and inspections are required for work I observed and for what is displayed in the pictures shown. Permits have been applied for. Permits has not been issued. The permit was issued from yesterday, but they just need to pay it, and from there they should be able to just get a final inspection and everything should be fine from there. So from yesterday, the permit was issued. Inspections have not been performed, Included in my file is a copy of the notice violation and the affidavit on posting. I have had contact with the owner, and she's going to be busy paying for the permit fee. Again, from thereafter, they'll be getting their inspection. The result of the contacts, speaking of improving of the special magistrates, the city recommends 30 days to comply, $50 per day after that. I am submitting as evidence a copy of this case file, including all documents relied upon.
Thank you, sir. And do you believe 30 days is a reasonable amount of time for the property owner to come into compliance?
More than enough. I think it should be done within a few days, hopefully.
Understood. Thank you. Special Magistrate, the city would like to enter the case file, including the photos and testimony into evidence, barring any objection.
All right, I'll accept those documents and testimony and evidence as city's composite exhibit. I guess I don't really have any questions. You did a very thorough job there. In CEBLD 241106668, I make the following findings of fact and law. I find notice is sufficient. I find property in violation of FPC 105.1 and 110.3. Failure to obtain the building permits for the roofing work and electrical they did there. Respondent has 30 days to come into compliance, or a fine of up to $50 per day may issue.
Case number 7, CEBLD 250-30725, case address 550th Street.
Kevin Pennington, Building Inspector for the City of West Palm Beach. The code case number is CEBLD 250-30725, and the address where the violation occurred is 550th Street. The violation I observed is a covered patio and room addition. I issued the violation and posted the stop work order on the property on March 6, 2025. The notice of violation was mailed via certified mail and regular mail on April 24th, 2025, and it was posted on City Hall on April 24th, 2025. It was posted on the property on April 24th, 2025. The certified mail was delivered on May 1st, 2025. To support my observations of the violation are floor, wall, and roof framing, sheathing, doors, windows, stucco work. The photos being shown truthfully and accurately depict the alleged violation and reflect what I'm testifying to. Permits and inspections are required for the work I observed and for what is displayed in the photos shown. Permits have not been applied for, permits have not been issued, no inspections have been performed. I've included in the file a copy of the notice of violation and affidavit of posting. I have had a contact with the owner, and he said he is applying for permits and complete all inspections. The city recommends 120 days to comply and $50 a fine per day after that. The time to bring the alleged violations into compliance is a reasonable amount of time. I'm submitting the evidence, a copy of the case file, including documents relied upon.
Nothing further from the city at this time. Thank you.
I'll accept an evidence the evidentiary case file in this case, including documents, pictures, and testimony of the officer as city's composite exhibit. So the work that requires permits is the ancillary structure here?
Yeah, if you keep scrolling, so right there, if you can zoom in, you'll see some fresh stucco work in the center of the photo.
Over there on the left, right?
Yeah, so they're kind of filling in that L. So the window to the left, that is all new structure. There is a photo of some framing and roof. It was earlier on in the process.
So multiple things.
Yeah. It might be on a different file.
So framing, roofing, and the new structure.
Yeah.
Okay.
Yeah. Right there. You see all the stick framing now?
Yeah. Well, even I know that needs a permit. All right. In case CEBLD 2503075, I make the following finding of fact and law. If I notice is sufficient, I Find the property in violation of FPC 110.3 and FPC 105.1. I adopt by reference to the testimony of the code officers the nature of those violations. Respondent has 120 days to bring the property in compliance or a fine of $50 per day may issue.
Case number 9, CEBLD 250100693, case address 808 41st Street.
Mr. Pennington, you're back. This is 808 41st Street.
That was complied.
Oh,
Yeah, sorry. I thought
No
it
worries.
was removed.
that's the best kind of case.
Okay. We have case 13, CEBLD 250-40739, case address 2269 Indian Road.
Did we skip 10 and 11? No, yeah, okay.
Code.
Welcome back.
Thank you. My name is Ryan Brown, Chief Plumbing Inspector for the City of West Palm Beach. This code case is CEBLD 2504-0739. The address is 2269 Indian Road. The violation I've observed is unpermitted work, canopies, tents, paint booths, makeshift paint booths, workstations, an office trailer, many over and over violations. This property is more of a nuisance. The case originated from that fire in that picture there, a case from the fire department who asked us to visit them for the fire inspection. During that fire inspection, many of the violations were observed. The original case, which is next, was started out with unsanitary conditions. There were trailers such as that one that had, I guess what you would call a dwelling, an illegal dwelling without proper sanitary facilities. So the next violation in the order is for the unsanitary conditions, but the unpermitted
But
work.
let's just focus on this one for now.
The unpermitted work is electrical that was installed, plumbing that was installed. The office trailer had plumbing installed in it. Lots of stuff all over the place. Most of it was cleaned up, but is not in full compliance. So the unpermitted work stands until it's all completely removed. There are makeshift canopy tents that are being used for paint booths that still need to be removed. Some of the plumbing is still there. And then in the process of all this, the water main at the front of this particular lot on this property was repaired by an unlicensed person who did not have the proper permit or inspections. The notice of violation, so I did issue a violation and posted a stop work order on this job on 4/16 of 2025. The notice of violation was mailed via certified mail and regular mail on 4/24/25. Was posted at City Hall on 5/1/25 and was posted on the property on 4/23/25. Certified mail was returned. The address on file had a forwarding address that had since expired and wasn't maintained, so the certified mail was returned. The pictures that are being shown truthfully and accurately depict the alleged violation and reflect what I'm testifying to. Permits have not been applied for and have not been issued. Therefore, inspections have not been performed. Included in my file is a copy of the notice of violation and an affidavit of posting. I have had contact with the person who rents that particular lot on that property. There are 6 total. The person who is in control, the tenant himself, has several occupants that sub-rent. I have also spoke with them. I have lost contact with the owner or the tenant, and the people that are occupying it currently have said that he's more or less gone off the radar and is no longer even in contact with them who they are paying the sub-rent for. The results of my contact with the person, Scott.
What is that a dog?
Oh, yeah, sorry. Those have been since removed, but those were Shar-Pei dogs that were, the animal control had been out there. He'd been breeding them. That was part of the unsanitary conditions. It was a pretty rough day. That was heartbreaking. There was also a couple birds that were stuck in cages that weren't being tended to, cockatiels.
Well, in this case, we're just dealing with electrical, plumbing, and temporary structures that were done
Correct.
without permits, right?
Yes, sir. Animal control has their job, fire has their job,
Yeah. well,
and they
I
also
don't, I
have a
don't do
car
animal
nuisance
control.
case with the code enforcement.
I'm here to talk about electrical, plumbing, and temporary structures that don't have permits, right? And as of today,
Understood.
they don't have permits?
Understood, correct. No permits, no inspections. My results of the contact with the tenant who is paying rent, Scott Kipp, is very abrasive. He wants to point direction to everybody else but himself, but he's the one that's in control of the property at the moment. Fire has had contact with the actual owner of the property. I have not. I have emailed him and told him that if he needs to reach out, but he hasn't contacted me, so. I'm recommending 60 days to bring the rest of it into compliance for the permits and inspections, or $100 a day after that. The time to bring that into compliance is a reasonable amount of time because the object is removal. So I don't think that the time for pulling permits is even relevant. I am submitting as evidence a copy of the case file, including all documents relied upon.
Thank you, sir. Nothing further from the city at this time.
All right, I'm going to accept and evidence the evidentiary case file in this case, including the pictures, testimony, documents submitted by the city, as city's composite exhibit. So they need permits for the electrical, for the plumbing, and for the temporary structures. Did I miss anything?
No.
No, okay. And you believe 60 days is a reasonable amount of time for them to do that?
Yes.
Okay. Now, in case CEBLD 250400739, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of code sections FPC 110.3 and FPC 105.1, specifically failure to obtain permits for electrical, plumbing, and temporary structures on the property. Respondent has 60 days to bring the property in compliance, or a fine of $100 per day may issue.
Case number 14, CEBLD 2501064, case address 2269 Indian Road.
My name is Ryan Brown, Chief Plumbing Inspector, City of West Palm Beach, code case number CEBLD 2501064. The address is 2269 Indian Road, West Palm Beach. The violation I observed is unsanitary conditions, living conditions without proper facilities such as bathrooms, showers outdoors with gray water running on the ground, laundry discharge on the ground. The dog kennels was part of that issue, but many different things, but mostly the living conditions without proper sanitary facilities. There's the shower. There's the trailer that was being lived in without bathroom connections. Not proper potable water. That trailer on the right, which you'll get a better visual of in a minute, was being lived in without any bathrooms or showers. Altogether, I think there was 4 different living quarters and then an office trailer that had plumbing installed in it, which is right there on the right. I issued a violation and posted a stop work order on this job on 1/14/25. The notice of violation was mailed via certified mail and regular mail on 4/24/25. Posted on City Hall 5/1/25. Posted on the property 4/23/25. The certified mail was returned again. The forwarding email address from the address that we had on file had expired and not maintained, so it was returned. The pictures as being shown truthfully and accurately depict the alleged violation and reflect what I'm testifying to. Permits are not required for what is being shown. It is an unsanitary condition that just needs to be corrected, which has not been done. That particular one that had the fan in it, just up 2 or 3, still exists. That trailer's been removed. So they're about 80%, but they still have a couple of the dwellings, I guess you would say, are still there. Personal belongings in it with an apparent occupant. So
What is compliance here? Taking down the dwellings or just removing
Removing
people
it,
from living in them?
yeah, removing personal belongings, beds, things that would indicate occupation.
So basically stop living in these.
Yes, please. So I have had contact with the owner, the tenant who was paying rent to the owner. Again, very abrasive and evasive, denying any responsibility. The reason for the fire was the conditions that were there, people living in it without proper wiring, etc. So that's the reason why all of us were there to begin with. The city recommends 60 days to finish cleaning it up and remove the unsanitary conditions. Otherwise, $100 per day after that. The time to bring the alleged violation into compliance is a reasonable amount of time. I am submitting as evidence a copy of the case file, including all documents relied upon.
Thank you, sir. Nothing further from the city at this time.
And I'm going to accept into evidence the object case file in this case, including the photos, documents, and testimony of the officer. Yeah, I don't have anything more to ask here. Case CEBLD 2501069 make the following findings of fact and law. If I notice is sufficient, I find the property in violation of FPC 116.1. Specifically, there are unsanitary conditions on the property and living areas without proper sanitary facilities. Give the respondent 60 days to come into compliance or a fine of $100 per day may issue.
Thank you.
Case number 15, CEBLD 2409065, case address 800 North Zapadilla Avenue.
Peter Valenti with the City of West Palm Beach Building Department, inspection coordinator. So this was for an installation of a sign without a permit. Well, just getting right to it, I can happily say that within the last week, they have complied fully with this case. So, they've got their permit obtained and they got inspections all taken care of, final inspection completed.
So you just want to comply this one?
Yes, sir.
All right. Done.
Case number 16, CEBLD 250-30729, case address 480 Executive Center Drive 5E.
Okay, this was for installation of flooring without a permit and without inspections, of course. Violation was posted March 7th, 2025. Notice of violation was mailed by certified mail and regular mail April 24th, 2025, posted at City Hall May 1st, 2025, and posted on the property April 25th, 2025. The certified mail was delivered and picked up on April 26, 2025. My observations at the site was the flooring installed without a permit. The tenant/owner allowed me in to observe the flooring and let me know that the permit was not obtained and they would go forward and get the permit as soon as possible. If there's photos available, all the photos taken were taken by me. I testify to that. So the
Have they-
permits have not been applied for, I'm sorry, the permits have been applied for, but has not been issued yet. The owner was very cooperative at the time, positive. They just haven't followed through with completing the requirements for their permit.
How much time do you want to give them?
It may be a situation in plan review needing more information, so I think it's fair to say, city recommending 60 days to comply, and then $100 a day after that fee.
Thank you, sir. Special Magistrate, the city would like to enter the case file, including the photos and testimony into evidence, barring any objection.
Without objection, I'll accept those into evidence as city's composite exhibit. KCEB LD 25030729, and make the following findings of fact and law. I find notice is sufficient. Find the property in violation of FPC 105.1 and FPC 110.3. Failure to obtain a building permit for the installation of the flooring. Respondent has 60 days to come to compliance, or a fine of up to $100 per day may issue. Looks pretty nice, though.
Yeah.
That concludes all the building permit. Now we're going to code. Let's see where we're at. Case number 10, CE 250-43434, case address 955 McIntosh Street.
Good morning, I'm Richard Pasmino with City of West Palm Beach Code Enforcement. This property was investigated in response to a complaint about the landscaping, lack thereof. I cited this property on April 16th, 2025. Certified mail was sent out on April 16th. It was returned. In addition, the property and City Hall were both posted on April 17th, 2025. The affidavit of posting, which reflects that it was also sent via regular mail, is notarized and attached to this case. This property was originally cited for Florida Building Code 105.1. During my investigation, I noticed other issues. One of them was a driveway that was extended without a permit. Landscape areas must be grass. There was the front yard landscaping was bare dirt, grass missing, and 94-446 2C3 for tree abuse. The large mango tree on the property was hat-racked pretty badly, as seen in the photos. All photos were taken by me. I had have contact with the owner and a representative they're using to get their permits about the violations and about the corrective actions. And as of today, the violations for the permit, Florida Building Code 105.1 and Code Section 94-442C1 are in compliance. The remaining issue is the tree abuse. The city's recommending a finding of fact, finding this property in violation of that code section. We're asking for a one-time fine of $250 a day for the tree. It does appear
One-time fine of $250?
One-time fine for the tree abuse.
For $250, because you said $250 per day.
Oh,
so-
no, sorry.
Yeah.
One-time fine of $250.
Thank you, sir. Special Magistrate, the city would like to enter the case file, including the photos and testimony into evidence, barring any objection.
All right, without objection, I'll accept an evidence the arbitrary case file in this case is city's composite exhibit, including the photos, testimony, and documents. So at this point, the only thing you're seeking is the $250 fine for the tree abuse?
Correct.
I guess it's the city's position that sorry, the damage to the tree is irreparable or irreversible in nature.
Yes, they permanently changed the function of the tree and permanently changed the canopy it had. It does look like it's growing back, but it'll never be the same.
Fair enough. All right. In case CE 250-43434, I make the following findings of fact and law. I find notice is sufficient. I find the property violated 94-446 2C3, which is tree abuse, which is the hat racking of that tree. I find that condition is irreparable and irreversible in nature, and I issue a one-time fine in the amount of $250.
Okay, we have one more building case that was actually not complied, and this would be case number 4, CEBLD 250-10698, case address 3321 Pinewood Avenue.
Morning again.
Morning.
Hello, this is, I'm an inspector, a building inspector, Raymond Stevenson. I work for the City of West Palm Beach. The code case number is CEB LD 25010698. The address where the violation occurred, 3321 Pinewood. The violation I observed is 2 prefabricated sheds installed without a permit and inspections. I issued a violation and posted the stop work order on the job on the 1st of the 16th and 25. I noticed the notice of violation was mailed via certified mail and regular mail on the 4th of the 25th. Was posted at the City Hall on the 5th of the 1st, 25th. Was posted on the property on the 4th of the 25th of the 25th. The certified mail was delivered on the 5th of the 1st, 25th. The observation to support each violation I'm alleging is 2 prefabricated sheds installed without a permit or inspections. The pictures shown truthfully and accurately depict the alleged violation and reflect what I am testifying to. Permits and inspections are required for the work I observed and for what is displayed in the pictures shown. Permits have not been applied for. Permits have not been issued. Inspections have not been performed. Included in my file is a copy of the notice of violation and the affidavit on posting. I have had contact with the owner. As a result of the contact, the owner is telling me that he's going to get rid of these 2 sheds when, I don't know, he's now had almost 5 months to remove these sheds and he hasn't complied as yet. The city recommends 60 days to comply and $100 per day after that. The time to bring the alleged violation into compliance is a reasonable amount of time. I am submitting this evidence, a copy of the case file, including all documents relied upon.
Thank you, Mr. Stevenson. Is the property owner aware that these code provisions are out of compliance?
Yes.
Okay, just wanted to clarify that. Thank you. Special Magistrate, the city would like to enter the case file, including the photos and testimony, into evidence, barring any objection.
Without objection, accepted in evidence, the city's composite exhibit. So this is 2 sheds, neither of which is permitted.
Yeah, he was hoping that he was going to make them habitable dwellings. He could rent them out. This is, you got to go to zoning first. I don't think they're going to accept them any motel.
So he could either get them permitted or he can remove them.
He could get them permanent, use his garden sheds, basically, or remove them. That's his
60
goal.
days is enough time to do either?
He's had 5 months to get rid of them.
Okay.
I think it's more than enough.
All right, in CEBLD 250100698, I make the following findings of fact and law. If I notice is sufficient, I find the property in violation of FPC 110.3 and FPC 105.1. These 2 sheds constructed or assembled or installed without a permit. Respondent has 60 days to bring the property in compliance or fine of $100 per day, may I issue?
Thank you.
Okay. Case number 11, CE 250-43435, case address 1003 McIntosh Street.
That is complied.
Okay, thank you. Where are we now? Case number 18, CE 250-43478, case address 915 Paseo Morala.
Good morning, City of West Palm Beach Code Enforcement Officer Paul McFarland. On 428, the property at 950 Paso Morella was cited for 18-106B, excessive growth, 18-103-B, repair, of rotted wood to roof. 94-71-C, outdoor storage. 94-302-A-4, repair and maintenance to fencing. 18-215-B, failure to comply. I'm requesting abatement on this property. Property was also cited for 18106-A, clean and sanitary. Property as well as City Hall was posted May 13th. Certified mail and regular mail was sent April 28th. Certified mail has been returned on May 20th. City's requesting an abatement for the excessive growth, the unsanitary conditions, and 18-105-B, failure to comply. City's requesting 15 days to abate those violations. It is a habitat for vermin and snakes. When I was out there visiting the property, the neighbor did complain of the vermin coming from that property because it's not being maintained.
Is anyone living here?
It gives me the impression that I think vagrants may be living there, but I don't think that there's an actual owner that lives in the unit itself, because I'm seeing things move around there, but I've never seen a vehicle in a driveway. Neighbor states that no one is living there. I don't have evidence to support that no one's living there.
I assume nobody's responded to your notice?
Yeah, no one's responded to the notice that I left at the door or the one that was mailed. This is why I'm asking for the abatement for the overgrowth and the trash. I'm also asking for a split order, 15 days for the abatement and 30 days to repair the rotted roof on the roof and to the fencing, or 30 days or $100 a day until those items are taken care of.
Thank you, Mr. McFarland. Special Magistrate, the city would like to enter the case file, including the photos and testimony and evidence, barring any objection.
Without objection, I'll accept that evidence, the documents, testimony, and other evidence submitted by the city as city's composite exhibit. So the city is seeking 30 days for the fence and the structure, and they're seeking 15 days or abatement for the clean and sanitary, the weeds, and the outdoor storage.
No, the outdoor storage is under the under the 30 days. We're only abating the trash and the overgrowth.
Okay. And it's your testimony, the conditions on the property constitute a threat to the health, safety, and welfare of the city, including habitat for vermin and disease?
Yes, sir, and neighbors are complaining as well.
All right, in case CE 25043-478, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of the following code sections. 94302A4, the fence is in disrepair. 18103B, the structure is in disrepair. And 9471C, there's outdoor storage. Just wanted us 30 days to bring those issues into compliance or fine of $100 per day may issue. I make further finding that the conditions on the property constitute a threat to the health, safety, and welfare of the city of West Palm Beach, specifically 18106A, clean and sanitary, and 18106B, excessive weeds. Respondent has 15 days to bring those into compliance, or I authorize the city to enter the property and abate any and all those violations, hereby assess the cost of the said abatement against the property and property owner.
Case number 20 CE 250-43427, case address 539 Green Springs Place.
Good morning, City of West Palm Beach Code Compliance Officer Paul McFarland. On April 3rd, I received a complaint from the tenant at 539 Green Springs Place. Upon my investigation, I cited the property for 22441 rental license violation and 22-32-A certificate of use. The property as well as City Hall was posted May 13th. Certified mail and regular mail was sent April 15th. Certified mail was signed for May 5th. I've had no contact with this property owner. With this being said, city's recommending 30 days to bring this property into compliance, or $200 a day until compliance is achieved.
Thank you, sir. Special Magistrate, the city would like to enter the case file, include the photos and testimony and evidence, barring any objection.
All right, I'll admit the documents, testimony, and evidence into evidence, the city's composite exhibit. So you met the tenant and the property is currently being rented?
Yes, the tenant did complain to me, but the complaint he had I could not address. But on further investigation, I noticed that there's no rental license for the property.
So there's not a rental license, nor has there been an inspection?
No, sir.
All right, and you believe 30 days is sufficient amount of time to accomplish this?
More than enough.
All right, in case CE 25043-427, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 2232A and 22441, a failure to obtain a rental license for a rental property. Respondent has 30 days to bring the property in compliance or a fine of $200 per day measure.
Thank you.
Case number 22, CE 250-53502, case address 939 35th Street.
Last but not least, huh?
Yeah, always. not a biggie. All right, good morning. Donald Lattimore, City of West Palm Beach Code Enforcement. The property at 939 35th Street was cited due to a delinquent business tax receipt, rental license, and certificate of use. I initiated this case on May 2nd, 2025, and this property is occupied. The property was cited for the following code violations: 82-144 to renew the business tax receipt, the business license, 22-32-A renew the certificate of use, and 22-441 renew the rental license. The city issued a notice of violation to the property owner, which identified the violations, my contact information, and notice of this hearing date. That notice of violation was noticed by certified and regular mail on May 2nd, 2025 by the city's clerk, and I posted a notice of violation at the property in City Hall on May 5th, 2025. I also completed an affidavit of posting on May 5th, 2025. I checked the City of West Palm Beach permit and license database and found the property still not to be in compliance with all of the code sections mentioned previously. The property owner is not present, but I made contact with the property owner on February 10th, 2025. Prior to issuing this case, the owner was informed of the need to renew the rental license, the business tax receipt, and certificate of use. The following documents show that the violation still exists on the property. For violation 82-144, which is the renewal of the business tax receipt, the city is asking for 10 days to comply or a one-time fee of $250. For violations 22-441 and 22-32A, that's the rental license and certificate of use renewal, the city is asking for 10 days to comply or $100 per day until compliance is achieved.
Thank you, Mr. Lattimore. Do you believe 10 days is a reasonable amount of time for the property owner to come in compliance for the alleged violation?
Yes.
Thank you. Special Magistrate, the city would like to enter the case file, including the photos and testimony and evidence, barring any objection.
So admitted, is this a commercial property?
No, it's a rental property, and one of the tenants, to my knowledge, inside of the rental property has a business that they're running, like an online business, or using it as an office.
Oh, and you confirm that they're occupying the property at this time?
Yes, I spoke to the owner, which he's aware of these items needing to be taken care of, and I did explain to him, if the business is not being ran anymore, just let me know, I can close the license. So that was all taking place on February 10th, again, prior to me even opening the case, and I have yet to receive any response from the owner. In the case file is also email correspondent where I reached out to him as well to let him know. So
Yeah. 10 days is a pretty sharp deadline. You think that's sufficient amount of time? And what do they have to do? They just have to pay?
sure, they just have to pay. The business license and rental license expired in September of 2024. Since then, the city has mailed multiple reminder letters to let all individuals know that their license have been expired. If I'm not mistaken, I think at least 3 was mailed to them regarding business as well as rental license and certificate of use. This is also a case that I have cited in the past to make them aware.
So they should know better.
They know, Special Magistrate, they know.
Okay. All right, in CE 25053-502, I make the following findings of fact on law. I find notice is sufficient to find the property in violation of 82144, failure to obtain a business tax receipt. I give the respondent 10 days to bring that in compliance or a one-time fine of $250. I make further finding that the property is in violation of 22441 and 2232A, which is certificate of use and rental license. Respondent has 10 days to bring that in compliance or a fine of $100 per day may issue.
Case number 23, CE 250-43438, case address 614 6th Street.
All right, good morning again. Donald Lattimore, City of West Palm Beach Code Enforcement. This case is in regards to a response team that the mayor requested due to members of our Northwest neighborhood complaining about vacant lots not being properly taken care of, our unhoused population, clean and sanitary in the area. So a part of the response, our homeless outreach team, police department, code enforcement, and sanitation pretty much got together and to address some of the issues in the neighborhood. So I was the representing code officer. With that being said, while on patrol, I observed trash and debris on a vacant lot. The vacant lot was later identified as 614 6th Street, and I initiated my investigation on April 16, 2025. During my investigation, I observed the following violations: 18106A, that's the clean and sanitary for the trash and debris; 18106K, landscape maintenance with the overgrowth, in particular tree where our unhoused population is congregating behind. And then I also cited for failure to comply abatement, which is the 18215B code. The city issued a notice of violation to the property owner, which identified the violations, my contact information, and notice of this hearing date. That notice of violation was noticed by certified and regular mail on April 17th, 2025 by the city's clerk. And I posted a notice of violation at the Property and City Hall on April 21st, 2025. I also completed an affidavit of posting on April 21st, 2025. I revisit the property on May 16, 2025, as well as May 20th, 2025, and observed the property not to be in compliance with the following code sections: 18106A, still trash and debris, especially towards the back area of the property line where members are sleeping, and 18106K, landscape maintenance. In particular, PD needs the trees trimmed and cut so we can see what's going on the vacant lot. I took the photographs at the initial investigation and when I revisit the property. These photographs accurately and truthfully depict the violations I observed during my investigation. And the property owner is not present, and I have not made contact with the owner or an approved representative. The city is asking for 21 days to comply. If no compliance, the city is requesting abatement to comply to violations, which means cleaning up any trash and debris that's on the property, and the trees that have the low palms, they need to be cut and trimmed so we can see. This is causing safety concerns and issues throughout the neighborhood due to the unhoused population in the area, and also the sanitation conditions, the lack of sanitation conditions from members of our unhoused population as well.
Thank you, Mr. Lattimore. And do you believe 21 days is a reasonable amount of time for the property owner to come into compliance for these violations?
I do.
Thank you, sir. Special Magistrate, the city would like to enter the case file, including the photos and testimony, into evidence barring any objection.
Without objection, the documents, testimony, and evidence submitted by the city are accepted in evidence as city's composite exhibit. So you believe the conditions on this property constitute a threat to the health, safety, and welfare of the city of West Palm Beach as habitat for vermin and perhaps attractive nuisance?
Yes, Special Magistrate, I do.
All right, CE 250434338, I make the following findings of fact in life. I notice is sufficient. I found the property in violation of 18106K, that the landscape maintenance, the trees need to be properly trimmed in a sanitary way. 18215B, failure to comply, and 18106A, clean and sanitary trash and debris on the property. I make further finding the conditions on the property constitute a threat to the health, safety, and welfare of the city of West Palm Beach. They constitute habitat for vermin and also an attractive nuisance. Respondent is ordered to come into compliance within 21 days, or the city is authorized to enter the property and abate any and all of these violations. I hereby assess the cost of said abatement against the property and property owner.
Case number 24, CE 250-53501, case address 1111 35th Street.
All right, Special Magistrate, with your permission, is it possible for us to jump to case number 26? Reason being is it's also a case that was just attached to the previous case that you just heard.
Sure.
Thank you very much. Agenda item number 26, please.
Agenda number 26, case number CE 250-43436, case address 623 4th Street.
Thank you very much. Again, this case is a part of the mayor's response team towards the area in our northwest neighborhood from members complaining about the safety and the condition of the area in general, especially with our vacant lots. So I'm Donald Lattimore, City of West Palm Beach Code Enforcement Officer assigned to the task. While on patrol, I observed trash and debris on a vacant lot, and the vacant lot was later identified as 623 4th Street, and I initiated my investigation on April 15th, 2025. During my investigation, I observed the following violations: 18106A, clean and sanitary; 18106K, landscape maintenance; 94-71C, outdoor storage; and 18215B, failure to comply and asking for abatement. The city issued a notice of violation to the property owner, which identified the violations, my contact information, and notice of this hearing date. The notice of violation was noticed by certified and regular mail on April 17th, 2025 by the city clerk. And I posted a notice of violation on the property in City Hall on April 21st, 2025. I completed an affidavit of posting on this date, April 21st, 2025 as well. I revisited the property on May 16th, 2025 and May 20th of 2025 and observed the property not to be in compliance with the following code sections: 18106A, 18106K, 94-71C. And I took the photographs at the initial investigation, and when I revisited the property, the following photographs show that the violations still exist on the property. These photographs accurately and truthfully depict the violations I observed during my investigation. The property owner is not present, and I have not made contact with the owner or an approved representative. With that being said, the city is asking for 21 days to comply. If no compliance, the city is requesting for abatement to comply to violations.
Thank you, sir. Special Magistrate, the city would like to enter the case file, including the photos and testimony, into evidence, barring any objection.
All right, without objection, I'll accept the documents, testimony, and pictures and evidence, the city's composite exhibit. So this is similar, right? We essentially have a vacant lot with trash and debris, landscaping that's not being maintained, and I guess in this case we have some extra items being stored on the property.
That is correct, Special Magistrate. And if I may, I want to point your attention to the re-inspection photos. And if you go up a little bit, Monique, on 516, you can see that I am actively working. Go up a little more, just a little more to the date 516, and go up, go up, go up. Here's a good example. If you look in that photo from 516, there's no tent behind that tree branch that's hanging down. And if you scroll down to just a little bit, just go down, Monique. Thank you so much. Keep going. for me, keep going. You already see trash and debris, and then there's a tent in a matter of 4 days. So this is one of the reasons why I wanted to point out the case that we need abatement. PD needs to be able to clearly see these lots, especially in the night. I'm trying very hard to get in contact with the owners to encourage them to put up that no trespassing sign. But this is what the community is dealing with. We do have a task force team that's trying to address our unhoused population in the area and assisting them with services.
So you believe people are living on the property in unsanitary conditions, which constitutes a threat to the neighborhood of disease and vermin?
That is correct, Special Magistrate. Thank you.
Okay, in case CE 25043-436, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 18106A. There is clean and sanitary. There is debris and trash on the property. 18106K, the landscaping is not being properly maintained. In 89471C, there is outdoor storage and other materials being stored on the property. Make further finding that the condition of the property constitutes a threat to the health, safety, and welfare of the city of West Palm Beach by constituting an attractive nuisance, habitat, and unsanitary conditions. Respondent has 21 days, respondent is also in violation of 18215B. Respondent has 21 days to bring the property in compliance, or the city is authorized to enter the property and abate any and all violations. I hereby assess the cost of said abatement against the property and property owner.
Our last code enforcement case on the agenda, case 24, case number CE 250-53501, 1111 35th Street.
All right, Donald Lattimore, City of West Palm Beach Code Enforcement Officer. The property at 1111 35th Street was cited due to a delinquent rental license and certificate of use. And I initiated this case on May 2nd, 2025. This property is occupied. The property was cited for the following violations: 22-441, renew of the rental license; 22-32-A, renew certificate of use. And this is also a repeat violation, 26-35-B for the repeat violation. In the code cases that I would like to cite the repeat violations for includes CE 24041746 and CE 21020094. The city issued a notice of violation to the property owner, which identified the violations, my contact information, and notice of this hearing date. That notice of violation was noticed by certified and regular mail on May 2nd, 2025 by the city's clerk. And I posted the notice of violation at the property in City Hall on May 5th of 2025. I also completed an affidavit of posting on May 5th, 2025. I checked the City of West Palm Beach permit and license database on 5/19 and 5/20 and found the property not to be in compliance with the following code violations: 22-441 and 22-32-A, renewing the rental license and certificate of use. The property owner is not present, but I emailed the owner a reminder to submit a payment to renew the license and certificate of use on January 27th of 2025. I also made contact with the property owner on February 10th of 2025 and advised the owner to renew the license and certificate of use and to make them aware of the possibility of a repeat violation. With that being said, the document shows that the violation still exists on the property, and due to the multiple repeat violations, the city is asking for a $50 per day fine starting from May 2nd, 2025, the date that the case was initiated, until compliance is achieved.
Thank you, sir. Special Magistrate, the city would like to enter the case file, including the photos and testimony and evidence, barring any objection.
So admitted. So do I read this correctly? This is the third time they've been cited for this?
Correct.
The same two code sections, 22-441 and 22-32A?
Yes.
Okay. And you confirm that the property is still currently being rented?
Yes.
All right, CE 2505351, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 22-441 and 22-32A. I make further finding that this constitutes a repeat violation under the Code of the City of West Palm Beach 2635B. I hereby issue a fine in the amount of $50 per day beginning when the Property was initially noticed for its third violation on May 2nd and continuing until the property comes into compliance.
Thank you.
Okay, gentlemen, that's the last case under our agenda.
What about 25?
With the,
Clyde, okay. You might have said it, I don't know.
we've been all over the place, but I'll confirm. Case number 25, CE 2505358, case address 1113 35th Street has been complied.
All right, we're gonna take a break until 11:30, is that when we're scheduled? All right, so we'll be back at 11:30. All right, I hereby call us back into order. This is the special magistrate for the city of West Palm Beach. This is the other matters agenda, beginning at 11:30. Cases are going to be called in the order in which they appear on the agenda. When you hear your case called, go ahead and proceed to the podium directly on my right-hand side. The city will introduce the case, then you'll have the opportunity to present what it is that you are asking me for. I think in most of these cases, you're asking me for a reduction of lien, so it's important if you're going to ask me for a reduction of lien to do two things. One, to tell me specifically what you're asking me for, and two, to give me a legal justification based upon factual information that I'm allowed to consider under the city code in order to reduce the lien. So make a specific ask and give me the justification for that ask. This is a quasi-judicial hearing, which means the formal rules of evidence do not apply here. However, all testimony is taken under oath under penalty of perjury. So if you're going to testify today, or you think you might testify, or there's a possibility that you might testify, I'd ask that you rise, raise your right hand, and I'll swear you in. Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury under the laws of the state of Florida?
Yes.
Go ahead.
Our first case in the other matter agenda is case 27 CE 201000095, case address 915 34th Street. This gentleman also has another case, which is case 31st under the same address, case number CE 240-72318.
Why don't we do them both?
Officer Williams, City of West Palm Beach Code Enforcement. For agenda item number 27, case number CE 201-00095, case address 915 34th Street. This case was originally cited, October of 2020. It was cited for excessive overgrowth, failure to comply, exterior paint needed, and overgrowth of the parkway as well. This case went to a special magistrate hearing November 4th of 2020. It was ordered for the fine to start as of December 7th of 2020. That ran for 1,199 days at $100 a day for a total of $119,900. This case was complied March 20th of 2024. Service in this case was achieved by way of posting as well as regular mail. This was done under the previous owner, magistrate. We do have an agreement beforehand to reduce this amount to $5,000 payable within 30 days.
Sir, can you tell me your name, please?
Travis Dupree.
Is that different from Tony Dupree?
Yes, Tony's my father.
And you're here on his behalf?
He passed away in September of 2023.
I'm sorry to hear that.
Yeah, thank you.
The city is representing that you reached an agreement to reduce the fine to $5,000 payable within 30 days. Is that an accurate representation?
Yes, Your Honor.
All right, in CE 201000095, I hereby reduce the fine from $119,900 to $5,000 payable within 30 days. If it's not paid within that 30 days, it returns to the original amount.
There's one more. Agenda item 31, case number CE 240-72318, case address of 915 34th Street. This case was originally cited in September of 2024. They were cited for landscaping need to be maintained in the front side yard, sod needed in the front yard as well as the parkway, and to cut the overgrowth from the parkway that was encroaching on the city's right-of-way. This went to a magistrate hearing September 2024. It was ordered for the fine to start as of October of 2024. That ran for 121 days at $100 a day for a total of $12,100, and was complied February 3rd of 2025. Service in this case was, as well was achieved by way of posting and regular mail. Magistrate, this was done under the previous owner. We do have an agreement to reduce this fine to $1,000 payable within 30 days as well.
Welcome back, Mr. Dupree.
Thank you.
The city is representing that you're in agreement to reduce this to $1,000. Is that accurate?
Yes, Your Honor.
All right, in case CE 24072318, I hereby reduce the fine from $12,100 to $1,000 payable within 30 days. If not paid within that time, it returns to the original amount. I think we got you out of here in time.
You're welcome. Case number 28, case at KCE 15100740, case address 1749 Village Boulevard, number 108.
Officer Williams, City of West Palm Beach Code Enforcement, agenda item number 28, case number CE 151000740, case address of 1749 Village Boulevard, Unit 108. This case was originally cited October 28th of 2015. They were cited for AC changeout without permit. A stop work order was issued October 26th of 2015. This went to a special magistrate hearing December 7th of 2016. It was ordered for the fine to start as of February 6, 2017. This ran for 2,474 days at $100 a day for a total of $247,400 and was complied November 16th of 2023. This was done under the same owner magistrate, only one case under their ownership. So the city requests a reduction to 15% of that lien, which would be a total of $37,110.
Sir, can you tell me your name, please?
William Eldred.
And what is your relation to the owner, Janice and Rocco Fort?
She just asked me to be here on her behalf. She's out of the country, out of the state. And so my company is called Easy Permits and Inspections. And I helped her through the process.
I must keep you busy.
You wouldn't believe.
So what are you asking me for, and why should I grant it?
If you don't mind, Your Honor, I have a copy of her original contract. You probably have a copy of it as well. And in her original contract back in 2011, she paid $250 for a permit. And I know, I mean, I've been doing this for a lot of years. I know that the permits fall on the responsibility of the homeowner. I know that, and I get it. But when you pay a contractor like USA Air $250 to take care of the permit for them, and they don't do anything, they basically stole from her. And on top of it, she had no idea there were any fines or liens or anything until she went to sell the property. And when she went to sell it, of course, they did a title search and found out she had the lien on there. It was her son that was living there. He just never forwarded anything to her. And so she got, that's why the fines went up. She didn't know. If she had known she's a financially responsible person, she would have definitely have taken care of it. But she didn't know. Shame on USA Air for doing what they did, but that doesn't get her out of her position.
You want to show that to the code officer? Have you seen that? Yeah, okay, so I don't.
Rebates on the back as well.
I'm sorry, I didn't write your name down.
What's that?
I didn't write your name down.
My name is William Eldred, E-L-D-R-E-D.
So what are you asking for, Mr. Elrod?
I'd love to see it reduced down to nothing, but I know that's probably not going to happen. But, I mean...
I'm not going to do that. But
I know, but I hate to say what's the minimum that they would take, because this lady, she's trying to sell her house, and with this on here, she obviously wouldn't be able to sell her house because of what USA Air did, years ago. Would $2,500 be reasonable, or $2,000 be reasonable for the city of West Palm Beach? I have to say,
they sold her an air conditioning and they didn't get a permit. Is that essentially what you're telling me?
Yeah. Not only did they not get the permit, they charged her for the permit, which is infuriating to me. I mean, that's what I do. AC companies hire me to pull permits for them. And when I see an AC company, especially a large company like USA Air Conditioning, that puts a woman in this kind of position, she's a single woman, an elderly single woman that's trying to sell her house. It infuriates me when I see stuff like this. So I think the best thing I can do is try to get her something reasonable where she can still sell her home and put a little bit of money in her pocket and take care of the city of West Palm Beach, what they're looking for at the same time.
What do you guys think?
Magistrate, given the fact that proper notice was given in this case, the city obviously is amenable to reducing it, so we were counting with 5% of that lien, which would be $12,370.
I know the homeowner can't afford that. I know she can't afford it. I already spoke to her before I got here. I know for a fact she can't afford it. I asked her what's the most you could come up with, like today if we had to, and she told me $2,500 is the most that she could come up with. Are you willing? I mean, would you guys be willing to go $2,500 on this under the circumstances? I mean, shame on USA Air for doing what they did, but you know, too bad they're not in here so that they can pay that fine.
It's a little trickier, right, because I mean, I have to weigh the severity, right, and the failure to obtain a permit tends to be a health and safety issue, which...
Of course. But
So-
who's
so
to
basically
blame
you
for
had-
that, the homeowner or the contractor?
Yeah.
You know?
I agree. Unfortunately, I can't pull the contractor in front of me and the home...
I know that.
As
I
you well know, the homeowners...
I wish we could. I wish we could. We'd had this room filled with contractors in this area, because every contractor out there does work without a permit. Every one of them do. I know that for a fact, because I've seen it.
How do you guys... Are you guys...
We would stay firm at the 5%.
Oh, my
only
goodness.
Especially
No
because the
chance that you
property
could-
is for sale, Magistrate. But we would leave it up to your discretion.
I'll give you the last word there.
I'm sorry, what's that?
I can't go down to 2,500. That's just on something this long that went without a permit for so long. I can go down to 5.
Let me ask something. If I can get her to pay it today, would you like maybe $3,500, split it with me?
I'll give you more time on the 5, but 5 is low as I'm going to go on this, because it's so substantial.
Okay, I'm going to ask for more time, but she'll probably want to get it paid, I would imagine, because I don't think she wants to drag it out. How much time can you give me on that 5?
Ask me.
An extra 30 days?
I'll give you 60.
Oh, better yet.
All right, 5,060 days.
Thank you, Your Honor, I appreciate it.
We are going to hear case 30, since I believe we're still waiting to see if case 29 shows up. Case 30 is CE 240-92772. Case address is 201 Nottingham Boulevard. Now, I have here on the sign-in sheet 2 different code cases, but I only have the 772 here.
Yeah, there's only one,
Okay, thank you.
the 772 case. Officer Williams, City of West Palm Beach Code Enforcement, agenda item number 30, case address CE 240-92772, case address of 201 Nottingham Boulevard. This case was originally cited back in November of 2024. They were cited for unpermitted use, electrical work that needed to be done, lighting repair in the bathrooms that needed to be taken care of, BTR and certificate of use required, outdoor storage, trash and debris, as well as landscape maintenance. This went to a special magistrate hearing November of 2024. It was ordered for the fine to start as of December 7th, 2024. That ran for 66 days at $1,000 a day for a total of $66,000. It was complied February 11th of 2025. Service in this case was achieved by way of posting and regular mail. This was done under the previous owner. The new owners are here today who have taken over the project and complied that all sections of the previous case, unbeknownst to them. The lien was then discovered. So we do have an agreement beforehand, Magistrate, to reduce this lien to 5% of that lien, which would be $3,300, payable within 30 days.
Can you tell me your name, please?
Lucia de Santa Ana.
Ma'am, the city is representing that you have an agreement to reduce this to $3,300 payable within 30 days. Is that what you understand?
Yes.
Okay. CE 240927772, I reduced the fine from $66,000 to $3,300 payable within 30 days. If not paid within that 30 days, it returns to the original amount.
Thank you.
You're welcome. Do we not have the people for 29?
Yeah, the respondent for 29 never showed up, so
Yep.
we'll reschedule that one.
Case number 29, CE 23390, case address 1029 Allen Road, did not show up, it will be rescheduled.
All right, well, let's reschedule that, and seeing no further business before us, there is no further business, right?
Nope.
All right, we're adjourned.